This is a protection meeting discussion on legal documents. So John and Mary, as we move down the list here, the next item on the list is wills, trust, power of attorney, and living will. So those four together kind of comprise your legal documents. And legal documents are an important part of your protection component in the event that you had either obviously a death or simply an incapacity where someone else had to make decisions on your behalf. So the first thing on the list is wills. And so for you, wills are important, but maybe not for the reasons you would expect. Most of your possessions, for instance, like your IRAs and your qualified plans, your 401ks, those pass via what's called beneficiary designations, which is actually listed on the IRA or the 401k. They don't pass via your will. And actually your house and probably most of your joint checking accounts and joint investment accounts, those pass via that joint account designation. They automatically move from one spouse to the other via the account designation. So those don't pass through the wills either. Your life insurance, that passes through beneficiary designation as well. So the will doesn't actually pass a whole lot of your financial assets through that legal document. But the will is very important, especially for you guys, to deal with what happens to your children, right? So what would happen if both John, you and Mary were in an accident together and both of you died and your children were left? Who would you want to raise your children? So one of the main purposes for the will is simply to establish the guardianship of your children, right? And that's the person that would raise your children. This is always a kind of a touchy subject among families because obviously both sides would love to be able to raise your children, but I think you need to think about in who your guardian should be. You need to think about who you would want to raise your children from the perspective of who would have the same value system, I think, as you do. So think about things like faith, parenting habits, beliefs, school choices, things like that. Who would have similar values to you? The other things you may want to think about is, let's say, John, you'd like your sister to be the person that raises your children if something happens to you, but your sister lives halfway across the country. Do you really want to put your children in a situation where both their parents have died and now you're uprooting them from everything that's familiar to them and moving them across the country? So that may not be the best thing either. So you need to think about geographic. And the last thing you need to think about is age. So a lot of younger couples will choose to have their parents listed as the guardians for their children. The only problem with that is sometimes it wouldn't be the best scenario to have a 70-year-old grandparent trying to raise a 10 or 11-year-old child. So those are all things to think about when you're establishing guardianship. The second big thing in the will is going to be the establishment of a trust for the children if something happens. So currently, John and Mary, you have $1 million worth of life insurance. And if something happened to both of you, that $1 million would go to the children, go to your children. So the problem with that is right now your children are minors. So whoever is raising your children would have access to that money through their guardianship because the children are minors. So perhaps the person that's the guardian who is raising the children the way you want them to be raised may not necessarily be the best person with money, right? Or you may want to have some checks and balances in place. So Mary, your brother might be a perfect person to raise the children. Him and his wife do things exactly the same way you do, but maybe his wife is a little bit of a spendthrift and you don't want to have your $1 million that's intended for your children to be in her possession where she could potentially spend some of that money. Or worse yet, and I'm certainly not saying anything about Mary, your brother, or his marriage or his relationships, but let's just say something happened where your brother either got divorced or your brother's spouse also died. Your brother may remarry, and now that new person who you don't even know now has some influence on that money as well. So the best way to handle that is to establish a trust, put the money for the children in a trust for the benefit of the children, and name a trustee. And so the trustee would be the person who's responsible for for distributing the money in the trust for the benefit of the children, right? So what would happen in that instance is Mary, your brother, as their guardian, would go to the trustee and say, I need money to send the kids to college, or I need money to send the kids to this private school that John and Mary really wanted the kids to go to, or I need money to buy them clothes or food or whatever, right? And so John and the trustee has the responsibility for determining what's reasonable and just making sure that it just puts a check and balance in place for it, right? And the trustee can be a person. It could be maybe somebody on John's side of the family if Mary's side of the family is raising the children, or it could be an institution like a bank. So banks bank trust departments take on that responsibility as well. So that $1 million would go into a trust for the benefit of the children, and then there would be checks and balances of how that money is distributed for their benefit. Additionally, when the children turn 18, if the money's not in a trust, then all of a sudden that money is fully available for your children to spend as 18-year-olds. Probably not the best scenario of two 18-year-old kids inheriting $1 million. There'll probably be a lot of Ferraris and really nice homes and trips to Europe and things like that. So let's try to avoid that and put in place in the trust some language that says maybe some of the money is available as they're younger, perhaps even just income from the trust, but the corpus of the trust, the $1 million, it stays in the trust until maybe points in the future. So maybe at age 25, age 30, and age 35, you start pulling some of the money out of the trust and distributing those in a lump sum to the children. Right? So you can have whatever language you want in there. I've seen trusts that say that whatever the children earn, if the children earn $50,000 a year, then the trust gives them an additional $50,000 a year. So it incentivizes the kids to go out and find good jobs, be productive members of society, all those things. Right? So you can instill whatever you want in the trust language so that those sorts of things happen in the future. So I would say trust language inside of the will is very important. So the guardianship and the trust language inside the will are the two main reasons that you're going to want to get a will in place. Now under trusts, you certainly don't have any need for an irrevocable trust at this point, which is used mainly to reduce estate taxes, which aren't applicable to you. A revocable living trust is a document that essentially allows your assets to be distributed via the trust document as opposed to going through the probate process, which is a legal process that the court system handles. So in the absence of a revocable trust, your money goes through a probate system. The parts that don't go via like beneficiary designation, those items go through a probate system, and a judge determines where that money should go in accordance with your will. But it is a public proceeding, so it is public record, and it is at the mercy of whatever the judge or the courts come up with. A revocable living trust handles all that in a private way, essentially. The other kind of nice thing about a revocable trust, and of course I'm not giving legal advice here, but from my experience, people can challenge. So if family members come in and feel like that money wasn't distributed properly and there's people fighting about things, people can challenge wills. So a family member, like for instance, if you marry your brother, gets the kids and all the money, and John, your brother and sister aren't happy about that, they could actually challenge the will in a court of law. A revocable living trust is much more difficult to challenge, so they tend to be stronger agreements as well. So revocable living trust, you guys can maybe think about that a little bit. You absolutely don't need to have it, but it may be something that you like the idea of how it works and you want to incorporate that as well. The last two things that you need to have is a power of attorney for a legal power of attorney, which says if either one of you are incapacitated, these are the people that can make decisions for you on legal matters. And then a healthcare power of attorney that says if either one of you are incapacitated, these are the people that make decisions for you in healthcare related matters. So those are important ones to have as well. The last thing on here is living wills, which is simply the desire for a natural death. That's a check yes or no sort of thing that is always included in will packages. So I would be happy. So I think those are all things that you need to put in place sooner rather than later. I know a lot of times wills don't get done because you have a hard time figuring out who you want to be the guardian of the children, who should be the trustee. Those are difficult decisions, but what I'll tell you is if you don't make the decision and then something happens to you, somebody else will make that decision on your behalf. And it may or may not be the decision that you would have made. So it's best to go ahead and get something in place. You can always change it in the future, but having those documents in place is a big deal. So I'd be happy to, so if you agree with that, let's put that down on our list as something that needs to be done at the end of this meeting, is to check with a couple different attorneys to figure out if they perform these different document services and how much they charge for it. I have some people that I'm very comfortable with that I've used in the past that have done a good job for me. I'd be more than happy to give you those people. If you have somebody you already have a relationship with, and I'm more than happy to assist you in any way I can in helping get those established.